21-36805 is called the State of Texas versus Louis Kotkin law. That is you, Mr. President, with Mr. Dusler, your attorney and the state's attorney. Does the defendant waive a formal reading of this motion to revoke probation, which was filed on April 12th of 2024? Can we proceed in assembly?
Yes, sir, but I think the state needs to amend counts 1 and 2 to go to the motion.
That's correct, Judge.
Mr. Kinlaw, raise your right hand. Do you solemnly swear or affirm any statement you make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Okay, lower your hand. Yes, go ahead.
Counts 1 and 2,
Counts 1 and 2.
there's a reference that this offense occurred in Chambers County. In fact, it occurred in Orange County.
Anthony Robbins.
So
So allegations 1 and 2 should reflect Orange County rather than Chambers County.
that's correct, Judge.
Any objection to that?
No, sir.
And that's what the defense understands is correct.
That is correct. And those are the counts he's going to be pleading truth to as well.
That is changed and corrected to without agreement.
This is the PC from that offense, really.
Okay. Allegation 1 here states that you committed the offense of operating a motor vehicle while intoxicated with a child under 15 years of age on or about March 10th, 2024 in Orange County, Texas, in violation of condition 1 of your probation order, which is don't commit an offense. Is that allegation true or untrue?
So,
Number 2 states you committed the offense of abandoning or endangering a child on or about March 10th, 2024 in Orange County, Texas against the peace and dignity of the state, also in violation of condition 1 of your probation order. Is that true and correct?
so
Are you pleading true and correct to allegations 1 and 2 voluntarily? No, intelligently, and because those allegations are true. Do you understand that a knowing and voluntary plea of truth of 1 or more violations of probation, that is enough to grant the motion to revoke probation? Your probation can be revoked. You can now be found. Stand by.
up to 5
No,
years.
you were on regular probation, so your probation could be revoked and you could be sentenced to no less than 2 nor more than 5 years confinement in prison for each. Knowing that, you insist on pleading truth.
So,
I find you pleading truth voluntarily. You understand and appreciate the consequences of pleading truth. This is unagreed?
that's correct.
Stand. You got a copy of this probable cause affidavit?
Yes, sir.
That's in tiny, tiny, tiny print.
Sorry about that, Judge. I blame the probation officer.
Okay.
Not yet. I just a little bit more.
Yes, that's not your actual.
Well, intoxication has been kind of your problem, hasn't it? On a bunch of different things here. Now, you're put on probation because a child was in jeopardy. And then now we've got some other allegations here. All involving intoxication. Okay. Go ahead.
Well, he absolutely recognizes that alcoholism is a problem. And he wants to address that problem. And in fact, he has voluntarily uh, submitted himself to substance abuse classes. He has a certificate will present to the floor showing that he has completed a substance abuse program to try to address that problem. He knows that that's a problem that's going to continue, that he's got to still deal with it the rest of his life. And he really believes if the court would continue him on probation.
Now, this was, where was this conducted and completed?
What I say, Jim?
At the state jail, when you were at the state jail.
Yes. And he actually served 15 months in state jail because of the Orange County offenses I mentioned in the motion to revoke. But what he and I have discussed, and he feels like that if the court would continue him on probation, it would force him to be monitored to where he can continue his substance abuse treatment. Hopefully, lick this problem that he's had with alcohol, and by the time that probation's over with, he'd be clean and be able to keep clean. He can do it on his own, but I think he's got a better shot of doing it when he's under supervision, and that's what he's asking the court to do: is consider keeping him on probation where you can monitor him.
Are you still on parole, though? Are you on parole for that state jail?
No. No, it was on parole.
He received a full 15 months, which he served. So in essence, what he's asking for is consider that as his punishment and give him a second chance. The state is in
How long, though? I mean, is that what you're saying?
Sure.
Well, I gave you a second chance when I put you on probation, July 28th, 2022. How many chances does someone get?
First of all, I didn't kill nobody.
Thank God. Yeah, I thank the creator, not you.
Yeah. I work for a living. Every time I came in front of y'all, I always had a job. I don't lie, I don't steal. I don't kill, so yeah.
But you've had a consistent pattern here now of putting children in harm's way. You know, anything wrong? Do you see anything wrong with that? That's terrible. You know I
That
do.
was only one time. First time through my operation, they didn't involve like.
How many times is too many? You got to agree. A child put in jeopardy because of your having that's.
I was put on probation. I was still in my addiction.
Probation. And it's kind of disappointing to me here because we have a 92% success rate and we're real proud of it on probation. 92%. I hate to see, I brag about it when I'm speaking at functions we're very proud of that because the national average is 75.
Right.
And we have a high rate of probation success, but it's because our probation officers are good. but you got to carry your own weight like always. You got to do some of the swimming here and the rowing. And
That's why I asked.
this was kind of disappointing. Well, you were sentenced the first time. What were you in the state jail for?
He was in state jail for those offenses, Judge.
For these that he just pleaded
yes,
true to?
Yes. Yes.
Okay.
If I may, Your Honor.
Was it out of this court?
No, sir. That was out of Orange County. That's why he pled true to it. He knows that he's guilty of it.
Okay.
When this man appeared before you,
How many
and
times do you have credit, please? Go ahead.
he's got about 220 days credit, is what we know, Judge. When we appeared in front of you, Your Honor, in 2022, there was a cap agreement of 5 years, and I argued for the 5-year TDC time because of the assault on a peace officer. That Your Honor made the choice, listened to his defense counsel make a really good argument that he needed some help, and we gave him an opportunity to be put on probation, despite the fact that he had 3 felony convictions before that sentence date. So now he stands here with 5 felony convictions, asking Your Honor for another opportunity. As you know, I don't agree with that. Had we sentenced him then, he wouldn't have had a new offense. Now, that's not me chastising the court. Your Honor is always really good about giving people an opportunity. Certainly saw that he could succeed. And in fact, the probation officer told me he was really doing well up until he committed this new offense. The problem is he only made about 15 months. And then he gets sent to state jail for another 15 months. If Your Honor does give him the opportunity, it's not one that I'm in agreement with.
Opportunity, what do you mean?
He's
Back
asking.
on probation?
Yeah, I just don't agree with it. I'm asking for 5 years, Judge.
Okay. Yeah, you get to say something. Go ahead.
Before this, I never took a alcohol anonymous class. I never had help by alcohol. I understand you gave me probation, but
Yeah, well, I kind of stuck my neck out.
you know, I needed more help than that, and I got it once I went to state jail.
Okay.
I was around other people that had addictions. We was able to help one another. I never had an alcohol class, so that was my first time taking it. Really help. All I'm asking is, can I continue to take it?
Sir?
All I'm asking is, can I continue to take it, continue to help?
There's nothing to stop you from continuing to do it on your own, but how many chances do you get? I mean, I don't open the door for you. I open it for everybody else. You were put on probation already. You failed. How many? Yes. I know the answer to it. I just, you know, it's your life. No one knows better than your life. How many misdemeanors do you have, and how many felony convictions do you have?
Well, felonies probably 3 or 4, and misdemeanors 2.
Yeah, 3 and 3, 6. But the point being is that you don't know for sure. You've read something about your own life.
Long time ago.
I know. But it's not something like that should never be in the past, because it should be in something that was important that you remember. But it had been a while. You're right. But the drinking problem is a problem. All right. Anything else to add?
No, sir. We have nothing.
If nothing,
I think he's expressed himself.
if nothing further, there is sufficient evidence supporting this motion to give both probation to grant it at the preponderance of the evidence. Good job, Marcus. We're working up here, folks. Thank you. That's allegation 1 and 2. correct, have been proven.
Yes.
As the defendant has pleaded truth, voluntarily, knowingly, intelligently to those allegations. And that is enough to grant this motion to revoke probation by a preponderance of the evidence or greater. Your probation is hereby revoked, sir, and you are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 4 years. You'll be given credit for you will be given credit for all time that you have served in connection with that. And this is yours. So I don't know if you'll be released immediately or if you're going to have to stay in a little longer, but fix all this mess, sir. Anything else?
No.
That is all. Thank you. By the way, Randy Arline, 25 CR 109 with David Grove, that has been dismissed for the record. And I'm sorry, reset. And David Grove's next case, Jeremy Barabin, 24 CR 1544, that case has apparently been dismissed. And you were Mr. Hall?
Yes, sir.
Okay, with Mr. Dusler, your attorney. 16-24463 is called. The state of Texas versus Devontae Montez Hall, present with Mr. Dusler and the state's attorney. There's a first amended motion to revoke unadjudicated probation, correct?
That's correct.
That's about as old as I am. Wow. That one's been. Have you just, was he?
He's been in the federal
prison
penitentiary.
waiting?
Yes, Your Honor.
Does the defendant waive a formal reading of this first amended motion to revoke unadjudicated probation? Can we proceed in session? Raise your right hand, sir. Do you solemnly swear or affirm any statements you make during this hearing will be the truth, the whole truth, and nothing but the truth, so help you God? Lower your hand. In summary, this motion states that on November 28, 2016, in this court, you were placed on 10 years deferred or unadjudicated probation for assault on a public servant. Do you understand what you're charged with here, sir?
Yes, sir.
Counts 1 and 3, I think. So,
Huh?
I believe 1 and 3 would be sufficient.
What are we doing on this?
It's
2 years.
2 years TDC.
Number one states you failed to report to the Jefferson County Probation Office on or since March 4th, 1st, 2017. It doesn't say an end, but it must have been for a long time. Is that true?
Yes.
Do you understand that was required of you under condition 4 of your probation order, a violation of one or more violations of probation orders? That's enough to grant the motion to revoke probation. Your probation could be revoked. You can now be found guilty and sentenced up to the full range of punishment. This was a 3rd-degree felony, so you were looking at no less than 2, no more than 10 years confinement in prison. Knowing that, do you insist on pleading true today?
Yes, sir.
I find you pleading true voluntarily. You understand and appreciate the consequences of pleading true. What else? Is it
1 and 3, Your Honor.
And 3 states you provided urine sample on or about March 1st, 2017, which showed the presence of cocaine in your system, a violation of condition 10 of your probation order. Is that true as it is alleged? And are you pleading true and correct to that voluntarily?
Yes, sir.
And you understand and appreciate the consequences of pleading true as we've talked about. So
Yes.
an agreement has been reached where you will be pleading true as you have done. Your probation shall be revoked. You will be sentenced to 2 years in prison. You will be given, of course, credit for all time you've served in connection with that sentence. Is that your understanding?
Yes, sir.
If I follow this, you have no right of appeal of this case. Do you understand?
Yes, sir.
Show you what's marked here as State's Exhibit 1. Did you sign that document voluntarily, discuss it with your attorney, or the contents true to that?
Yes, sir.
State's Exhibit 1 is tendered into evidence without objection admitted. This states you understand that you are giving up all rights of appeal if I follow this agreement.
Yeah.
I'm going to do that.
Yeah. All right.
Anything else? If not, I'm going to find there is sufficient evidence supporting this motion to revoke probation to grant it by a preponderance of the evidence or greater, as you have Mr. Hall had pleaded true voluntarily, knowingly, intelligently to allegations 1 and 3 of his first amended motion to revoke unadjudicated probation. Thus, your deferred or unadjudicated probation hereby revoked. Earlier in this case, you had pleaded guilty voluntarily and you were mentally competent to do so. You understood and appreciated the consequences of pleading guilty. There was sufficient evidence from State's Exhibit 1 admitted at your plea to find you guilty beyond a reasonable doubt at that time. Deferred any finding. Now, we are resurrecting that all those documents and those findings. And since your probation is hereby revoked, I hereby now find you guilty of this assault on a public servant, which was a third-degree felony. And I am following this agreement. You are hereby sentenced to confinement in the institution division of the Texas Department of Criminal Justice to serve a term of 2 years. Do you understand what has happened today, sir?
Yes.
Anything else?
No, sir.
Okay, that is all. Thank you. Okay, you heard us all talking about you. You needed to
Okay.
But,
get our attention. I mean, we were about to send another warrant out. Well, that would have been a waste with you sitting 25 feet away.
We're ready.
You ready?
I didn't even know he was here.
Nothing. We
just
can't.
also is, it's just out without a bond, so.
Yeah, I mean, we got to fix this bond thing first. I mean, before we do anything.
Yeah, have a seat right over in there, sir. Have a seat right over in the jury box. Thank you.
Second.